Okay, we are on. Adam, Elissa, and I got so busy chatting and having a nice side conversation that we forgot that it was time to start. So nice to see everybody again. I'm Greg Siskind. I am joined by my law partners, Adam Cohen and Elissa Taub. And Adam, I see you've got the logo on there. Good job. Um, Elissa and I are we're talking about basically like, do we blur or do we not blur the backgrounds tonight? So I went without the blur. But next week my new office is gonna be ready on there, so people are gonna see like my permanent, long-term, new fancy background for with bookshelves and all kinds of things. So I'm very excited about that. All right, so we I don't know if people have been here before that are already here, but basically the format is we're going to brief you guys on the week's news and immigration. Um, Try and mix it up as far as not talking only about in business immigration or deportations, but kind of give you a mix of the news. Then we're going to dive into a little bit into a specialized topic, a tips area. We're going to talk tonight a little bit about employers um, preparing for potential ICE activity at their work sites. And then we are going to take your questions. So if you are watching this on YouTube or LinkedIn or Facebook or X, I think those are the four places that we're on. It's very easy to ask questions. All you need to do is post a comment or a reply like you would to a post in those, and then we see them on our screen here, and we can choose questions that we think the audience would be interested in. I will tell you the most likely way to get your question answered is not to go on too long about a personal situation with a lot of your own facts, but to do something that might have some interest to a broader group. And then, but we'll try and get to as many as we can. So I'm going to actually have Elissa introducing the topics tonight, and then Adam and I will chime in. And we can also, if you have news that we forgot about that you want to tell us in the comments, you're more than welcome to.
Greg, do you want to start or finish with the ICE actions? I had it number 1, but we can do it.
Yeah. So this was we're talking about the tensions and the activity.
I guess like the workplace tips.
Oh, let's do that after we've done the news.
So I think actually the first thing on my list is the news that came out today about this year's H-1B cap lottery filing period, the registration period. That information came out just this afternoon, and USCIS announced that the cap registration period this year for those who want to register in the H-1B lottery is going to run from noon Eastern on March 7th to noon Eastern on March 24th. So we get a decent amount of time in there to get all of those online registrations done. A few things to note about this year that might be a little different than last year. First of all, the government filing fee for submitting cap registrations is rising from $10 to $215. That was announced last year in April when USCIS unveiled its brand new fee schedule, so that we already knew about that, but it'll become effective for this cap. And then USCIS also said in its announcements that it's making some enhancements to the online portal where we do the cap registrations to make it a little bit easier for law firms to assist our clients in getting those done. Last year, we could only connect one paralegal to one attorney, and we were making like multiple emails for our paralegals, so that it was just kind of messy. So USCIS took that feedback, and it sounds like they've made some upgrades in that regard to make the filing process a little bit easier for us, which we very much appreciate. And I think those details will be forthcoming. They usually do some webinars and sessions where we can kind of learn about the updates for this year. So we'll be looking forward.
I will say that two quick comments on that. One is I do think actually this will have a impact on how many H-1B registrations there are. I think that's, that it's just obviously the laws, the laws of economics that, they have made the price 25 times higher or whatever it is, at 250 or 210. And that is a lot of people in the past have filed a lot of applications because it was essentially free on there. So I do think that $250, and some people thought it should have been even higher, that would basically weed out less serious applications and multiple. They changed a lot of the rules to make it harder to do multiple applications. Some of you may remember they went away. They flipped the lottery last year, which was something that I had that we had actually did a mass lawsuit a couple of years ago asking the agency to do that, because what would happen was we would have individuals would get offers from 10, 15, 20 companies, and they would be entered into a lottery for each offer. And it was really unfair. Now the lottery is it's a one per customer deal. So if you can have multiple entries with multiple businesses, but your chances are still the one on here. So they've fixed the lottery so that it's a individual specific lottery rather than a position specific lottery. So that helped the odds this past year. But the raising of the fee, I think, is also going to get the numbers down. So don't be surprised, even though the economy is still doing fine, that we see a lot fewer people and the odds improving. So I think that's good. The other thing I was just going to say about Elissa is it's these little things that when the agency fixes it, like on paralegal accounts and all that, that they tend, they could have basically decided to have been jerks, I guess, with the new administration and all of that this year. So it is a sign that there is still some normality at the agency. They still kind of are seeing their day-to-day work as, going. So I like to see that kind of thing on there, these little normal things that, and I think we saw the last go around a lot of very abnormal little things that were happening, but we haven't seen quite as much. Now, obviously, that's not the case on some of the other news we're going to be talking about in a second.
Right.
But at least on employment-based immigration, no news is great news.
Yeah. I would just add to that also that USCIS, even, all during the Biden administration, was doing a lot of these feedback sessions where they would invite attorneys in. So there was sort of that collaboration that probably led to some of the things that we see. And we just can only hope that there will be some semblance, some continuation of that collaboration, at least on the digital side, right? The tech side.
Yeah.
So, yeah, I do think, sorry, hold on. But I do think that, and I like to thank the agency when they do good things.
Yeah, Elissa, before you get to the next one, I did, because I forget, we didn't talk about, there was that breaking news that happened this afternoon on the birthright citizenship, where there was another court that this time imposed an indefinite injunction on birthright citizenship, which is really important, because the other one, I think, was was going to be coming up again soon, and it still was leaving people uncertain on here. So not necessarily, this is not the death of that executive order, but it is the death for a good while on there, and probably until after. I don't think the Supreme Court would get to this probably until after the next the 26th election for Congress, and by that point, it may not be an issue anymore. But that's the thing for people that are. I think we already had a question about that, but that's something that people can really probably put out of their minds for a while.
Yeah, I agree. Okay. So the next thing, going from good news to maybe not such good news, is the revocation of TPS for Venezuela.
Yeah. So this is 300,000 people, I understand, that are in the TPS program. It was revoked, which I guess, Elissa, was it effective immediately?
No, it was published in the Federal Register yesterday, I believe, and it goes into effect 60 days from the date of publication. And the the designation for Venezuela TPS that's being revoked was the redesignation that was done in 2023. And I understand that most of those folks, their TPS already expires in April. And I believe the 60-day mark gets us to about April 5th or 6th, something like that, because February is a short month.
Okay.
So I don't know exactly the difference between when the TPS would normally expire and when this revocation becomes effective. It's close
I think
in
it's the
time.
same. Yeah.
And it may even be the same. So basically, the idea is that folks from Venezuela who have TPS won't be able to extend, and no new people can register or apply for TPS based on being from Venezuela. And so that was unfortunate.
Yeah, I mean, I think the main thing as far as like alternatives that are available to these folks, first of all, their EADs, their employment cards, I guess also will be ending at the same time that their status ends. So that's obviously not great. And people can obviously look at family options. They can look maybe at employment options. I don't think we have a E2 status with Venezuela. But in any case, probably asylum for most people is going to be the major option that's available. And they will. It is probably good just to remind people as well that there is normally a 1-year rule that you have to apply affirmatively for asylum, but that rule has exceptions for changed circumstances and other things. So it's probably, if you are in that situation, make an appointment with an immigration lawyer and talk about whether that might be an option that's available to you or not, or maybe there are others that are available to you. But that being said, I think those folks are going to have to act obviously very quickly.
Yeah.
And unfortunately, even if they file for asylum before it expires, they're going to have a period of time without work authorization, because the work authorization for asylees, you're allowed to apply for it, I believe, after 150 days. It's 180 days they would have to do, but you apply at 150 days, I think, for it. They have been sticking to 30 days, which I think is by regulation, that they have to adjudicate an employment card within that period of time, and they have been meeting that. I don't know if they will still meet that, but that's the big issue, I think, for a lot of people that are going that route, is that they are going to have to figure out how to survive for that period of time without the ability to work legally.
Yeah. No. Go ahead, Adam.
Oh, I was just going to add, there's oftentimes many students who also have TPS. And so I would just think about, any students who might be in that situation, just depending on the unique circumstances and maybe when F1 status might have lapsed, it might be interesting to look into the possibility of an F1 reinstatement. And there's also, can be possibilities to change status from TPS, in certain situations as well, to another status, like maybe an H-1B. So just some other things to put on.
And let me mention why you should be listening to Adam on university issues, and Elissa, especially on any issues involving physicians and healthcare, even though Adam's quite good on that as well. Adam and Elissa are both authors of books on those subjects. Adam writes a wonderful book, The Academic Immigration Handbook, and it's basically probably the most authoritative book that's available to the public on that subject. Elissa is the author of the Physician Immigration Handbook. Also, it's a book a lot of lawyers have on their desks, but it's written in plain English so that doctors and others can and people at hospitals can also understand very easily what's in there. So I wanted to plug those before we forget, but they're excellent. They're both those books are available on Amazon.
Okay. Next, the President Trump on Friday, I want to say, issued a new executive order on artificial intelligence, and that initially revokes President Biden's prior executive order on artificial intelligence. And President Biden's order, was pretty wide ranging and directed agencies of the federal government to do this full scale review of how they could enhance policies of the government to help the AI industry. And so that necessarily led to some updates with regard to national interest waiver based green cards and EB-1A green cards and O-1s and things like that, where the government actually in the USCIS policy manual implemented new policies to specifically recognize that folks that are working in the field of developing artificial intelligence tools are working in the national interest and that we should be acknowledging their contributions. So we have this new executive order that came out on Friday that repeals that and directs these same agencies to do a full-scale review of the policies that the Biden administration implemented to see if maybe they needed to be updated in light of the new administration's AI approach. So that's a lot of words to say we don't really know. No new policies have been announced yet, and the Biden administration policies have not been revoked or repealed to date. But it's something to keep an eye on. We expect that, both USCIS, maybe the Department of State or others may be tweaking or revising in some manner the AI specific policies that have been implemented.
I think a lot of times it's good to sort of like ask the all important framing question here, which is it good for Elon or bad for Elon? And in this case, the changes made by the Biden executive order on AI were good for Elon. So my guess is probably they won't mess around with those. That's just my take, but that's sort of how I frame things these days on the immigration front.
I think that there are going to be some tweaks because I think it's very hard for this administration to leave anything in place that was done previously. So even if the tweaks aren't necessarily bad, I think they're going to mess with some things. But that remains to be seen if they're going to be big messes or little messes. They know how to do both. So we'll kind of see.
I'll just add to that. I had to dig into this a little bit because, of course, many people will think about the STEM-related policies for O1s and for national interest waivers and EB1s, and they'll be, wondering if that's also affected. And it's not explicitly affected, right? Like this was, I think it was in early 2021. And it wasn't even an executive order. It was like a fact sheet. So, I mean, it is susceptible. Let's put it that way. But the Biden administration, put this sheet out. It expanded STEM OPT categories. It helped to change NIW EB1 O1 policy. It created some STEM J1 opportunities and things of that sort as well. And that's all still happening. And the language is still in the policy manual for O1s and EB1s and all that. This came later. This was in, I think, 2023 was this Biden executive order. Yeah. And there's definitely some things that came from the policy memo that came into effect after the executive order that added some additional language and considerations. But as of today, it's still all up there. And the other thing was, in this executive order, it talked about looking into a new exchange visitor skills list, which of course we have. It's already been issued in the Federal Register. So I don't think that's going anywhere. And then the other thing, I don't know if you wanted to comment on this at all, Elissa, but the Schedule A.
Oh, I just made a note about that as you were talking.
Yeah.
So
that's not happening.
It's interesting. So Schedule A, for those who don't know, is a list of occupations for which the U.S. Department of Labor has declared that there is a permanent shortage. And for those occupations, you don't have to do a full-on labor certification for an employer to sponsor one of those employees for a green card. You do a truncated process that we refer to as Schedule A. Right now, there are only 2 occupations on Schedule A, and there have only ever been 2. And those are registered nurses and physical therapists. That's it.
I have to comment.
Group 1, right?
The last time that list changed, I had a full head of hair and no gray.
But the interesting thing is, so in 2023, I want to say, maybe middle of the year, later in the year 2023, the Department of Labor put out a kind of like a request for information to the public to say, hey, in light of the Biden administration's executive order on AI, how would you suggest that we update Schedule A? And they took comments and then they extended the period. And I think maybe March of 2024 was the deadline to submit comments. And it was on the regulatory agenda. But for the fall and going into the spring of this year, the Department of Labor took Schedule A reform off its regulatory agenda, which means that for the time being, that effort is dead, which for me as an immigration lawyer who primarily works with physicians is mind-boggling, because I think that would be like the easiest occupation to add to Schedule A, since there's such a huge physician shortage in the country. But for right now, that's not happening. Doesn't mean it can't come back. Doesn't mean they won't revive the effort. Maybe Trump's EO sparks that again, but remains to be seen. But for right now, no Schedule A reform, sadly.
All right.
Okay, next thing. Greg, do you want to talk about the story that you saw recently about folks who have been detained by ICE being
So Julia Ainsley, a great reporter from NBC News, she's one of the elite reporters on immigration in the country. She had an interesting report that was, I think, came out 2 days ago. And the Trump administration has been in this shock and awe period with trying to make the news every day about deportations and et cetera. She had reported that, they had been publicizing that I guess they've 8,000 arrests since Inauguration Day. And her story was that even though they've arrested 8,000 people, they've actually started releasing some of the people back into society that they had arrested. And why? Because they don't have the capacity to deal from a detention perspective with all of the people that they've been arresting, which was what was being warned all along before the election. And unfortunately, a pretty sizable chunk of the people that they detained were not, in fact, the hardened criminals that everybody thought they were going after. So, I think probably people, if they were full up with just all of these violent criminals that they had found, okay. But, most of the people that were being arrested were people at work, people picking their kids up from school, people coming out of church, people work, and that's where most of the arrests have been happening. It has not been the criminal class that people were thinking. And they don't have they have limited bed space at ICE. They have to get funded by Congress. And the administration said they were going to focus on the hardened criminals, but instead they went and picked up a lot of what I call, the low-hanging fruit of removal, which are people that are, hardened criminals are pretty good at evading the law. That's why they're, that's one of the important skills in criminality, is that you avoid police and you avoid arrest on there. But normal people who are just like a law-abiding, good members of the community, those are the easy ones to scoop up if you want. And they were also picking up a lot of people who had past removal orders that were on supervision. In other words, they were from countries that weren't taking them back, or they had humanitarian reasons why they were here or whatever. But these were people that had to check in with ICE periodically, and so they check in, and magically they are they're in detention on there. Big surprise. So talk about the real criminals are not coming for the check-ins on there. But anyway. With that said, I thought that was interesting because I think it tells you a lot about a lot of the changes. And a lot of not just immigration, but a lot of spaces with the administration, which is a lot of it is about optics and not about reality.
Mm-hmm. Definitely. By the way,
all I have to say on that.
I did want to mention, because we had a question, we are taking questions tonight. You can put your questions in a comment or chat on whatever platform you are viewing us on. And we're going to go through a little bit more of our discussion of the week's updates, and then we will get to the questions soon. So please feel free to put your questions in whatever chat you have access to.
All right.
Okay, next thing. There was a report this afternoon in the Wall Street Journal, and it had been previously bandied about as well, that the president is looking for some reason to implement a travel restriction at the southern border based on Title 42, which was, if you remember, during COVID, they implemented travel restrictions at the southern border, basically saying, people who are coming in are bringing disease or bringing COVID with them, and so therefore we can keep them out. And so there was a report this afternoon in the Wall Street Journal that he's looking at both measles and tuberculosis as potential things to blame immigrants for. I will save some editorial comments on that.
I won't.
Except if you look at his HHS secretary who doesn't believe in vaccination, we might want to blame him for any measles outbreaks. That said, I will open that up for some discussion.
Yeah, I mean, I think Title 42, I mean, the main thing that they want to do is there are a lot of rights that the United States has provided to people based on our treaty obligations regarding asylum, for example, and rights people have to have the ability to seek asylum and make a request. But I believe under Title 42, they don't get credible fear screenings and most of the other stuff. It's sort of just a blanket reason why they can be excluded without having the ability to have those rights available. So that's what's really happening here, is that they're trying to find something that will allow them to use executive authority to do away with things that are required by law. Bottom line.
Yeah, no, it's a very frustrating consideration, right? Because we know that the president likes to scapegoat immigrants for all manner of things that he's angry about. And, right now I know there is a little outbreak of tuberculosis in the Kansas City area, and there have been intermittent measles outbreaks in different places amongst folks who aren't vaccinated. And so, trying to use that as a pretext.
That's the measles outbreaks are happening not in the immigrant communities, but in the the anti-vax, MAGA, anti-vax, super far weirdo lefty. Well, I don't know. I'm not saying we're going to be, but basically use your, the news has been reporting on it enough, but basically measles outbreaks that are happening around the country are not, that's not where they're happening in immigrant communities who are more than happy to take vaccines when they have them available.
Agreed.
It's just a series of throwing darts at a dartboard type of policies, I think.
Yeah.
This is just
it's just, and it's so clearly pretextual, right? Like it doesn't have any basis in fact. It's just like, hey, what could we use as a reason to try to keep people from claiming asylum at the southern border? Oh, I know. Let's blame them for diseases, right? Like that. It's really, it doesn't take a genius.
Yeah. The good thing is, I think, unlike COVID, where they actually, I think they loved COVID in the Trump administration because it allowed them to do travel bans and Title 42 and all these things. And nobody could say that it was made up. It was like a legitimate pandemic on there. So they were able to use that as the excuse to do a lot of things they wanted to do. Now they don't have that. So they're making up, like, pretextual is the term, because that's what a court is going to be looking at when they review some of these policies. And I am much more optimistic that the Trump administration is going to face problems when they go up in front of a judge on that issue.
Yeah. Okay. Last topic before we get into the ICE actions thing is the executive order from last week on anti-Semitism. And I know, Adam, you wanted to mention a few things about this with regard to its potential impact on F1 students.
Yes. So I wanted to mention it because I believe last week, Greg, a viewer had asked about it. And so I just, it doesn't do very much in and of itself. And I realize that, I'm trying to navigate this in a way that we're kind of just sticking directly to the executive order and politics aside and everything, because people really need to know, what does it actually say? What does it do? Has anything changed right now? Right. And so basically, it is having every federal executive department reviewing and reporting, trying to like read it as it's saying, still trying to digest it, but reporting to the White House within 60 days on all criminal and civil authorities and actions available for fighting anti-Semitism. So it's not really clear, but it might be trying to look into databases and information that is available through other enforcement agencies and things of that sort. I think we'll maybe get some meat on the bone ultimately as these policies perhaps start to roll out. The fact sheet was not really a fact sheet; it was really more to scare people, I think, and it mentioned something about possible revocation of visas and canceling visas and things of that sort. And I just, there's nothing out there that is indicating that is happening, right? There's nothing that's talking about a prudential, revocation of visas or anything of that sort. That has not changed. The other thing is they're talking about, let me see. There was something about reporting or educating universities, and see if I can find it, but educating universities about INA section 212A3. It's basically various security related grounds. And I'm not really sure what they're looking for ultimately and how they're going to try to collect information. It might be people who could have been arrested during these protests, and maybe they'll have some information there. Obviously, if we're talking about convictions anyway, we're talking about possible issues with student status just based on the conviction itself, right? But there could be, other concerns, of course, if any of this resulted in disciplinary proceedings and led to suspension or expulsion. These are things that are already potential grounds for termination through SEVIS. But conduct, having participated in protests, things of that sort, as of now, there is no SEVIS termination reason for that. It doesn't necessarily indicate that anyone's has failed to maintain status. It's not a cause for revocation of visas and things of that sort. So we're kind of, we're on the status quo at this point, just pending what we may find out after 60 days have passed, and maybe there's some more reporting that occurs.
Adam, sorry.
Well, I'm just curious whether you think that. I mean, I think some of this impact might come on the State Department and visa issuance side, at least of the, it might be harder to kick them out of SEVIS, but, I could see this being more of an issue when people are going in and seeking new visa stamping. If some of the stuff is, they're collecting a lot of information. I think that's the thing, is that there will be potentially more visible to consular officers about a person's background. And they have a lot more discretion at that point. They could say 214B is not just about whether a person's going to overstay or work illegally. It's also whether they're going to be doing anything, I guess, that violates the law or where they wouldn't be in compliance. And I guess that, we know from the past Trump administration that there seems to be a much more of a lower bar for a consular officer to deny a case than there might have been. So that's probably, I think, where we might see more of the issue.
I agree. And they use 214B really liberally now. So I think that could be an issue. And I do think eventually we might see, for certain cases, maybe some prudential revocations of visas, which is, where the State Department revokes your visa while you're here. So you don't have to leave. It doesn't revoke your status, but it means that if you leave the United States, the visa that's in your passport is no longer valid for travel, and you'd have to go to the embassy again and reapply. And that's where this potential for a denial of a new visa comes into play. And so I think that I agree. I think that's where some of this, I also find it interesting, Adam, that, this executive order directs the Department of Education to take certain steps and create certain reports, but then they're trying to abolish the Department of Education. So who knows? Maybe they'll never have any reports, and all of this I don't know.
Yeah. I do wonder, I agree with you all that I think that probably the more likely situation, if they're going to go down that road, would be some type of visa cancellation. But I think it would be to be determined, and I guess that's what's kind of mentioned in this executive order in terms of how they're going to marshal some of this information. What the credibility of the information has to be. Is there going to be some type of pressuring, of universities to report certain things? I guess I wonder about that, particularly within certain states, within certain state governments.
Yeah.
Well, I think universities have also been more inclined in the last couple of months to discipline and expel students for that were participating in protests, and that obviously leads to immigration, very quick immigration consequences if that happens. So I think, my takeaway is that just students in general that are here on F1 visas just need to tread very carefully about doing things that, outside of the classroom, outside of, that are potentially going to put them in the crosshairs of the administration, which, I'm a free speecher and I'm not too thrilled with any of that, but that seems to be probably the advice that I would give the typical F1 student is just keep your head down and don't, that if you want to participate in those activities, you just have to understand that there's a consequence that may mean that your time studying in the United States may end.
I'll just say, because I've been fielding some of those calls, I'll just say that, to those who kind of have been caught up in this is just to, we will continue to report back as we have more information about it.
Yeah.
All right.
Yeah, I just want to add one last thing on that, and then we'll switch topics. Is also just to remember that executive orders are not laws in of themselves, really. They are statements of policy. So this executive order, like all of the other ones that we've discussed this week and in other weeks, are all about directing government agencies to act, collect information, file reports, create policies in line with certain ideas, right? So the executive order doesn't say that, everybody of a certain type or that's taken certain actions is going to lose their F1 status or that they're not being deported. I know there have been a lot of reports about, using that kind of strong language, and that's not what this does. So there's no, there may be risk coming, but the risk is not, and so as Greg said, be careful about what you do now that you know that this policy, that this is the policy of the administration. But for past conduct, right now, nothing is happening of which we're aware, and there could be actions taken, but right now things haven't really changed all that much.
Yeah, why don't you just sum it up as like threats and data collection? That's like what that
Yeah.
is about.
Pretty much.
All right, but stay tuned on that. All right, so we're done with the news, right?
Yes, that is the news.
All right, that means I get to put up another banner.
Yay!
So we're going to talk about today. Last week we said we were going to talk about employers preparing themselves for potential ICE activity. And it really comes in two places. One is on the I-9 front and one is on worksite rates. So I-9s, for those of you who are not familiar with the term, they are the form that every person working in America, mostly, fill out on the no later than the first date of employment. And this is almost 40. It's 39-year-old law that basically Congress deputized all the employers in America to be part of immigration enforcement. And how they do that is employers are supposed to verify the identity and the authorization to work of every one of their employees. And they do that using this form called an I-9 form that the employee fills out, and the employer has, they fill out a section, the employer fills out a section, and the employee has to provide documents proving identity and authorization to work. And they could be documents that do both, like a U.S. passport or a green card, or it could be just an identity document, which might be a driver's license, or just an employment authorization document, which might be a social security card that doesn't have that annotation on it that most of the H-1Bs out there know, which is not valid as evidence of work authorization. So they do what ICE does what are called these desktop raids. And desktop raids are I-9 audits where they come and they demand to see the employer's I-9 forms. The employer has 72 hours to comply, and then then ICE will review them and make determinations later on. And there's a lot of employers that are very lax about their I-9 records, or employers that don't even keep I-9 records. And the first tip is to start for employers is to start preparing for an I-9 audit. And that means doing an I-9 self-audit. And that would involve basically going through and doing a review. And it's probably a good idea to have that done outside of your business. Law firms are the main places that you go for that. But in any case, what you don't want are people that were involved in managing the I-9s, doing the audits of their own I-9s on there, because they're incentivized in some respects not to be too diligent in what they're finding. But basically, these I-9 audits are involve first a review of all the I-9s. They go through field by field. Every mistake on an I-9 form is a fine. There's a maximum fine. I think it's like $2,500 a form now. I think, or it might have even gone up from that. They just raised them recently, but it can be fairly expensive if based on what ICE finds. And ICE also, that's just paperwork violations. If they start seeing patterns and evidence that an employer was knowingly bringing people on and just playing games with their I-9s or committing fraud with them, that can give rise to the level of criminal conduct. So you need to do an I-9 audit and find out what kind of shape your I-9s are in, and then do a thorough training at your work for the people that are working on it. And don't just push the I-9 function down to the lowest level HR intern that just happened to start a week ago on there. It is a very serious function, and it's something that employers need to have in their employee policies and have regular trainings on it, and make sure that they have a good system in place. There also are electronic I-9 systems that are out there where employers can do, it doesn't have to just be done by paper anymore, and it can be done on a web page, and it's a lot easier than it used to. So that's the first thing. You guys have anything else you want to add on I-9s?
Nope.
Okay. Let's talk about ICE raids. So, because that's what's been getting the real a lot of the publicity. We talked last week about the New Jersey raid where, I don't know how many hundreds of people, well, there are several raids in New Jersey, but there were a lot of people that were picked up on work sites. We were just chatting before the live stream began of just a local restaurant here in Memphis. That's a lot of people go to and where ICE agents just showed up in plain clothes and ordered dinner. And then after they were full, decided to go, went back in the kitchen and arrested all the people that cooked them their dinner on there. Very classy. But that's a little work site raid. So they come in all sizes. But basically, there are a number of things that, for employers. So first of all, if you've done an I-9 audit, you have some pretty clear, and it's pretty clear that most of your work, you have a lot of problems with your workforce as far as their legality goes. You can make, assessments about whether you need to have changes in that to, and there or not. But assuming that putting that aside, what you ought to be doing as an employer is, at least first having some kind of written plan for an ICE raid and you don't need this you shouldn't have this just in the Trump administration. ICE raids came during the Biden administration. They came during the Obama administration. They've always been with us. But basically, this means sort of having a protocol of who, what people are allowed to say what in communicating with ICE. So it may be that, and also it's understanding what parts of your work site you'll allow ICE agents into, the public parts or the non-public parts. It's training your workers, to know what the difference is in an area of the work site that ICE agents can be in and what they are not. They are, training them not to interact with ICE agents, and if they have requests, you basically say you're not allowed to enter. Talk to my employer. It's educating your workers as well. So, for example, it's like, telling them remain calm, don't start, running for the exits, because that sort of, gives ICE a pretext to assume that there are immigration violations that are happening when there might not be. But it's going through all of that, and then it's also making sure that employers, know their rights about what ICE is allowed to do in public areas, what they're allowed to do in private areas, where they need to have a warrant signed by a judge, versus things that they can do without that. So that's that. Basically, if you have that written plan, you'll be going through all of these questions, and it will make it easier for your employees. It'll make it easier for the employer. It'll make it easier for, the staff that are dealing with the ICE agents to all act according to the law, which is important. And it's like making sure you have an understanding of what the law requires and what it doesn't require. And, hopefully minimize the situation as far as, it's not a good situation, but making it as least disruptive as possible for the company.
I think it's important too, when you talk about, and, an employer should have a plan. And I think, we're focused here on talking about work sites. I think sometimes, obviously, a work site can also include people who are patrons of the work site, whether they are, customers at a restaurant, whether they are patients in a hospital, whether they are shoppers in a store. ICE is taking this tactic that when they come in and they do a raid or they do a sweep of a premises, there may be some people on their list that they're looking for, but they're going to sweep up other people who they might encounter while they're there, who also might be vulnerable. And so I think it's important for business owners to, in preparing and planning, it's really important to have like a phone tree. If there's more than one leader of the organization, maybe you have a hierarchy of, CEO, COO, maybe there's a president and a vice president of the company, whatever it is, there needs to be more than one person that can get that phone call when somebody comes into the premises and says, I'm here from ICE and we're going to come in and et cetera. Like, you have to have a plan in place for people to say, okay, well, I'm not letting you in until I talk to my boss or until we call our lawyer. Then you call the boss and the boss isn't available. Maybe they're on an airplane. Maybe they're somewhere. There has to be a second person, right? So it's important as an employer is putting together these plans to really think about, like, practically, what are your frontline folks going to do? I always think in terms of hospitals, but a lot of times the people who sit at the information desk or at a reception desk in a hospital are volunteers. There may not always be the same person. So there needs to be a reference on the desk there, something where somebody knows, in case of a government agent, visiting, here's who you call, and here's your second and third choices of who you call. I think that these are really, really important things for employers to consider, and not just to protect your workers or to consider your workers, but also to consider how this impacts potential patrons and customers as well.
Yeah, and I put up you can screenshot it, although this is being recorded and people can look at it. A very good guide for employers that the National Immigration Law Council and the National Employment Law Project put together on there, which is one of the better things that I've seen on this subject. So I would go and definitely look at that document as a starting point for putting together, whatever plan you're going to do. So I think we'll leave it at that for tonight, and we move into questions.
And I've written them down. I wasn't sure how many we were going to get, so I started making notes.
Okay.
So the first question relates to comments made by Stephen Miller and others in the organization, in the administration, about efforts to try to denaturalize folks, and what that might look like, and if there are any updates on discussions or plans to go through denaturalizations. Because
denaturalization was to Trump version 1 what birthright citizenship is to Trump version 2. That was their shock and awe thing, which is, we're going to take your citizenship away, and we're going to find all this fraud that people use to get their green cards and their citizenship, and we're going to, and I don't know, maybe 20 people were denaturalized during the entire Trump version 1 administration, because the vast majority of the people are not committing fraud. And it is and there's all this background checking that's happening in all these processes. So they didn't find much, and they didn't do much in that space. And I haven't heard them mention much about it this time. Have you?
I'd have to think that USCIS officers would be really offended by these efforts, because they work hard to, assess these cases. As much as we complain and take USCIS to task, they have a lot of officers that work on naturalization cases all around the country, right? You can't naturalize without having an interview. By law, you have to appear in person at a USCIS office and sit
after you've had the FBI background checks.
Right. And sit before an officer and answer questions and take your tests and all of that stuff. So I think I have had questions in my practice this week about it from people who are nervous. I know there's been discussion. I know Stephen Miller has said, like, we're going to go investigate. They did the investigations the first time too. And as Greg mentioned, they didn't really come up with a whole lot. And this is not easy to take somebody's citizenship away. There really has to be proof that a person obtained their citizenship through fraud, meaning you're not the person that you said you were, you lied on your application about something material. Like, it's a pretty high bar for the agency or for the government to come back and say, hey, you've been here for 30 years and you've been a citizen for 7, however long it is. And, all of those years ago, you lied and we're going to take your citizenship away.
Yeah.
I think
the only person I know who might be guilty of that is Mr. Musk.
Maybe Elon. But I think that there's a heightened level of anxiety. I've gotten questions about this in my practice over the last 2 weeks. This is not the thing I would lose sleep over. I don't think that this is not a, hey, we're coming for everybody who ever became a naturalized citizen in the United States. That's not what's going to happen. And in terms of any updates on it and what's going on, there has been nothing formally announced on these efforts. So there's nothing that's been updated in the Immigration Services policies about it. There's nothing that's been updated in ICE's policies or in the immigration court policies about, putting people into proceedings to try to take away citizenship. So none of those rules have changed as of today.
I don't know when they would find I get when they're going to find the time for it. All right, we'll let's move on.
Second question is, any significant changes in the way that USCIS is adjudicating I-129s or EAD extensions?
No.
Nothing yet. Yeah.
Nothing yet.
Nothing I've seen.
It's been crickets when it comes to those issues, although, and I think there's another question coming up on it in a minute. I do see discussions happening about H4 EAD, so we'll wait till that question comes up. But that's that would be the only thing I would say.
We can pivot to that question now. And actually, I think there's 2 things on this that are important. So there's an issue with regard to concurrent adjudication of H-1Bs, H-4s, and EADs, and then the H-4 EAD issue. So I don't know. I mean, I'll mention there, and maybe Adam, you can chime in on this too. There was a court settlement called that we refer to as Edakuni or Edakuni.
I'm not sure how to pronounce it either.
I don't know how you say it. I read it all the time. EDAKUNNI is the
one of our impact litigation litigators, Jesse Bless, was involved in that case.
So back several years ago, H-4s and H-4 EADs were taking a very long time to be adjudicated. Lawsuits were filed. USCIS settled the lawsuit and agreed to go back to their prior policy of concurrently adjudicating H-1Bs, H-4s, and the related EADs that were all filed at the same time, where the H-1B was filed with premium processing. They've been doing that pretty reliably since that court settlement. Not always. There have been some outliers, but pretty reliably since that settlement. The settlement expired on January 19th, conveniently, and USCIS said, well, we're not going to re-up that settlement. We're not going to continue that agreement, but we're still going to do it as a courtesy, not because we're required to, but because we can and we are. And I'm still finding that in my practice. I have heard anecdotally, some folks are seeing some H-4s be separated, but I'm still getting them adjudicated together. And I can tell you there has not been an announcement from USCIS that they're refusing to adjudicate them together. Adam, would you say that's right?
Yeah, that's true. Yeah, I mean, I think that it's really been crickets altogether, and
Yeah.
they could remove that type of adjudication at any point, and they really wouldn't have to announce anything either, right? Because it was always a settlement that had a deadline, and we always were hopeful that it would be extended. So we'll just have to see. But we were using it as, just strategically, and somewhat dependably, you could rely on that bundling. And I don't think that it's something that you can necessarily rely on, though you can certainly try to get those bundled.
I've been advising clients that we expect that the cases will be adjudicated together, but we can't guarantee it. And so, it may be on a case-by-case basis. If a particular officer is really busy, they might split them up. And if they're not, they might throw them in together. Like, I just don't know.
Was there anything in the new H regulation on this issue?
No.
Yeah.
No, nothing about it.
All right. What about just as we're talking about EADs on there, I mean, the two that seem like they got the most aggravation from the Trump folks the last time, and were STEM OPT EADs and H4 EADs, both of which were created in Democratic administrations, I believe.
I mean, they both came during Obama.
They both came during Obama. At this point, there's been litigation and all that, and everything's kind of like basically survived all of that. Do you think that the new administration is going to try and take a swipe at these two programs again?
I think they will on the H4 EAD. I'll let Adam comment on the OPT in a second, but on the H4 EAD, so in the America First executive order, the trade one, the America First trade one, there is a paragraph way at the bottom of that executive order that directs the administration to look into certain immigration policies. And I do think they mention EADs. They mention EADs as a bundle. They don't specifically say H4. And then there was another one, I can't remember which other executive order, but there's another one that also directs a review. And I do think because for the folks, especially the Stephen Miller wing of this administration, the H4 EAD has been something that they always have disliked. Now, the last time around, it was actually a lawsuit that tried to get the H4 EAD kicked because they were trying to argue that people working using H4 EADs were stealing American jobs, which is just not true. So the fact that there's no sponsorship needed and no LCA and all of that, that lawsuit ultimately went away, but and the H4 EAD survived. But I don't believe there's been any specific rescission regulation that's ever been proposed. So the last administration, they were kind of relying on this litigation to try to get that kicked out because the H4 EAD became available only in 2015. So when Trump took office in 2017, and before that, there were the lawsuits had been filed. So they were kind of hoping that the lawsuits would get the thing kicked, and then it didn't. So this time around, I think they're reviewing it a little bit more closely, and maybe the plan is to propose a regulation to rescind the H4 EAD program, which was created by regulation.
Yeah, I mean, it's not that easy to rescind a regulation, even by regulation. So it's not just a question of like going through the process. You have to actually show that there, were important policy considerations making the previous, especially if it's a recent regulation, why something important was missed on there, and that this new regulation has to correct that. And so that means you have to go in front of a judge at some point if you get sued on this and be able to prove that. So I am, even if the Trump administration wants to go after it, I do think that there's a reasonable chance that they would lose in litigation.
I agree. I don't think, first of all, as we've been saying, like, this is not the kind of thing where the administration can just wake up one day and say, this doesn't exist anymore. It's in a regulation. It's not just a policy. And the regulation is, those of you who might have H4 EADs or might have spouses that have them, not every person in H4 status is eligible to get an EAD, right? Like there are steps you have to take, you have to have an approved I-140 out there or something. So this is not like something where like everybody willy-nilly gets an EAD. So I do think it's going to be a long road for them to try to take this away. Certainly not something I expect to go away, in the next few months or even the next couple of years. I mean, this is something that's going to drag out. So a little bit of comfort on that, I think. Or I hope. And then Adam, if you want to talk about the STEM OPT stuff.
Yeah, I mean, on the STEM OPT side, there's been a lot of litigation. I think even predating. I mean, yeah, it was predating the STEM extension. 24 months.
I think it started in Obama,
at least.
Mm-hmm.
Yeah, but I think it started even before that STEM extension, and it was challenging STEM OPT. Ultimately, was challenging OPT as well. It survived like every iteration of this litigation. And the STEM regulation as it stands, I mean, it has a compliance structure to it as well. So it's not. It wasn't all benefit. It did have a compliance and an enforcement structure to it as well. I think that, there's certainly been interest, and I think even during Trump 1.0, there was interest in, reforming and modifying, and you would periodically you'd see it on the regulatory agenda, but then nothing really materialized. And I also know that there's been some scrutiny related to CPT, particularly day one CPT and things of that sort. But that regulation has been around for a very long time for CPT.
Yeah, we're only 3 weeks. What are we? 2 weeks or 3 weeks in on this? We're in the middle of week 3 right now.
Right.
It feels like forever, right?
There you go.
Already.
Aaron Hillis, we see your question. Hi, Aaron.
Hi, Aaron.
If you watch the recording, there was this a web address we put up that had a really good document answering your question on there. So if you can't find it, email Adam or I or Elissa, and we'll send it to you. But you should be able to see it there.
And I think her question came in before you post. Like her question was up there, so hopefully she was able to see the link when it was up there. But we can always send it to you.
Oh, Orlando Love had this last question, but I'm like, is that true?
Yeah,
that's interesting. So
I think so.
Question was USCIS was exempt from the buyout, which the buyout is completely illegal, and all these people who are like rushing to get their to accept the buyout, I'm sad for them that they are eventually going to be like most people have relied on promises from Trump in business that they are going to not get what they expected on there, but for the same reason that Biden lost on the on student loans relief, Trump is going to lose on that. Congress hasn't authorized money for that, and all of those people who are quitting their jobs thinking they're getting this big payout are going to get some sorry news, unfortunately, and they're not going to get their jobs back.
I know in a prior week you all talked about the hiring freeze. I think really that is a bigger issue, maybe not for USCIS per se. Where I worry about the buyouts and the hiring freeze is more with the Department of Labor, with the adjudication and handling of perm labor certifications, LCAs for H-1Bs, H-2B application, labor certifications. And stuff. There are a lot of immigration work goes through the Office of Foreign Labor Certification at the Department of Labor, which already does not really have enough people to handle the record levels of applications that they receive. And that's probably the place that I have the most concern about when it comes to these buyouts and the hiring freeze. Not so much on the USCIS and maybe a little bit on the State Department front, but Department of Labor is really where my anxiety lies.
The remote worker stuff is actually a big deal, though, for USCIS. But they do. Each agency has the ability to exempt as needed, and a lot of people don't realize that the USCIS service centers and a lot of are employing a significant chunk of their workforce is working remotely for those agencies. If everybody was required to come into work, that would mean a massive workforce reduction at those agencies because a lot of people don't live in the same cities as USCIS.
And over the last couple years, because of their remote work arrangements, USCIS actually downsized many of their service centers and moved. Remember, like we've had address changes of like, where do we send stuff? Because they moved the California and they moved the Vermont service centers. They redid the Texas service center.
We have one that's completely virtual now. The Heart Service Center doesn't even
Yeah.
have a location. It's like basically scattered across the country, the people that work for it.
Yeah. So I think that I think the return to work stuff for USCIS won't be as big a deal as it might be for other agencies that do have big physical plants that are sitting empty. Orlando asked another question about how quickly the processing slowdown will be, which I think is funny. But I think
that's gonna be the last question though.
Yeah. Right now, knock on whatever my desk is made out of, for good luck, I have not seen any processing slowdowns in my work, and
we are expecting it, but it hasn't happened.
We're braced. We're ready. But it's hard. We can't tell anybody when that might happen or what it might look like or where it's gonna. I feel like it's gonna be whack-a-mole, and they're gonna pop up out of nowhere. Some of these delays, and we just don't know yet.
Yeah, I mean, between hiring freezes and just any type of policies, right, that come about, like returning employment-based interviews and really starting to flood field offices, and just any other policies that just kind of gum up the system by requiring officers to do extra work, right, and analysis.
Yeah, so far USCIS has been status quo for the most part, few little changes, but most things are the same. And I think that's largely because there's not a permanent director in place. And the people who are there right now are, as far as I can tell, are career professionals that have been with the agency a while. They know how the agency works and they understand what their role is. And so they're caretaking to a certain extent right now. So I think it'll be a while before we see any massive changes, but I think once we get more permanent leadership in that agency that's more aligned with the administration, then all bets are off.
All right. Well, we've ended another hour, and we have we've provided some useful information on immigration. We will be back next week with some combination of our lawyers. Hopefully, I'll be on, and I don't know if Adam and Elissa want, I don't know when you guys are coming back, but hopefully you'll be back. And we just, let people know this is our regular schedule. Wednesday at 7, even though occasionally we have to move it around for one reason or another. We'll update you on the news. We'll answer your questions and hopefully help everybody keep calm and carry on. So see you next time.